Can pro forma sessions block presidential recess appointments? Imagine a scenario where the United States Senate is not actively conducting business but instead is holding brief, routine sessions without substantive debate or legislative activity. These are known as pro forma sessions. The question arises whether such sessions can prevent the president from making appointments to federal positions during Senate recesses. To understand this, it is important to explore the legal and constitutional framework surrounding recess appointments and Senate procedures. The United States Constitution grants the president the authority to fill vacancies that may happen during the recess of the Senate by granting commissions that expire at the end of their next session. This process is known as making recess appointments. The purpose of this provision is to ensure the functioning of government when the Senate is not in session. However, the scope of what constitutes a Senate recess has been subject to legal interpretation and judicial review. Pro forma sessions are typically very short meetings, often lasting only a few minutes, during which no significant legislative business is conducted. These sessions are scheduled to prevent the Senate from being officially in recess for a continuous period. The key legal question is whether these brief sessions can be considered an actual Senate recess that would bar the president from making recess appointments. The Supreme Court has addressed similar issues in the past. In the case of National Labor Relations Board v. Noel Canning, the court clarified that a recess must be of a certain length to trigger the constitutional restrictions on recess appointments. The court ruled that recesses of 10 days or longer qualify as recesses where the president can make appointments. Short pro forma sessions, often lasting only a few days or less, are generally not considered sufficient to constitute a recess under the constitutional standard. Legal experts and courts have consistently held that pro forma sessions do not interrupt a recess for the purpose of making appointments. The reasoning is that these sessions are not substantive meetings and are often scheduled solely to prevent the Senate from being in recess. Therefore, the president can still make recess appointments during these periods because they do not meet the length or substantive criteria established by judicial interpretation. In summary, pro forma sessions, due to their brief and non-substantive nature, do not typically block the president from making recess appointments. They are viewed as a procedural tactic rather than an actual recess that would invoke constitutional restrictions. This understanding helps maintain the balance of power and ensures that the executive branch can function effectively even when the Senate is not actively engaged in legislative business.